Hello everyone, this is Carla de la Rosa-King, immigration attorney, and today I want to talk to you briefly about the public charge rule. As we all know, USCIS has already said that they are no longer applying the public charge rule from August 2019. So what happens if you filed your adjustment of status application on or before March 9, 2021, and USCIS issue a request for evidence or a notice of intent to deny that is due on March 9, 2021 or later. So what happens? If you're in this situation and you receive a request for evidence or a notice of intent to deny pertaining to the public charge rule or Form I-944, USCIS says that you do not need to respond to the section of the request for evidence or the notice of intent to deny that pertains only to Form I-944 or the public charge rule. However, you do need to respond or to address the sections of the request for evidence or notice of intent to deny in connection to the eligibility of the benefits sought. For example, if USCIS issue a request for evidence or notice of intent to deny requesting you for a lot of supporting documents in connection with Form I-944, let's say they want you to submit credit scores, credit reports, details about the applicant's health insurance, etc. But they are also asking you to submit, for example, the applicant's birth certificate, because maybe when you submitted your application, the birth certificate's applicant was not legible, or the one that you submitted is not the one that was issued by the proper authorities in your home country, etc. So if you're in this situation, you do not need to respond or address the section of the RFE that pertains to the public charge rule or the Form I-944 form, but you do need to address or submit the documents in connection to the eligibility of the benefits sought. If, for example, in this case that I mentioned, you still will have to submit the applicant's birth certificate that USCIS is requesting you to submit. So it's very important that if you receive a request for evidence or a notice of intent to deny, read it carefully. So when you respond to it, you address it properly. If they are asking you for documents that are not in connection with the public charge rule or the I-944 form, you still need to respond or submit the response to USCIS. That being said, even though USCIS guidance says that if they're only asking you for documents or evidence in support or in connection with Form I-944 or the public charge rule, you do not need to respond to their request. It might be wise to still respond. I mean, you don't have to submit the documents that they're requesting, but in order to avoid any wrongful denial, it might be wise to still respond, and then just when you respond, don't submit the documents in connection with the I-944 or public charge rule, but respond and say something saying that the public charge rule is no longer in effect, so you are not submitting, therefore you are not submitting the documents in support to the public charge rule. This is just to try to avoid any wrongful denial. You don't have to. I mean, USCIS has already issued guidance that if the RFE or the notice of intent to deny is only asking you for documents in connection with the public charge rule or Form I-944, you do not need to respond. So again, it's very important that if you receive a request for evidence and a notice of intent to deny, you understand exactly what they're asking, so you can properly address the notice. So if you're in this situation, if you have questions, if you have a request for evidence or a notice of intent to deny, and you are not sure whether what exactly you need to submit, please feel free to give us a call at 773-366-1214 and schedule a consultation with me. I hope you find this video helpful, and thank you for watching.